Emani Green's motion to dismiss her from the Shanquella Robinson wrongful death lawsuit has been denied. The judge's order was filed on the 1st and then uploaded to the docket on the 4th, but I have been slammed with work. Work always takes priority, and so I have been on hiatus. We are going to break it down today. Certified law nerd, bona fide non-attorney, this is not legal advice, just my interpretation of what I'm seeing in the court record. Let's begin. Let's get into what the judge actually ruled. The order starts by laying out the background of the lawsuit. Emani Green asked the court to dismiss her from this lawsuit, arguing that she was not properly served, that service was too late, and that the plaintiff could not fix the issue now because of statute of limitations concerns. If you need clarity on what any of that means, please check out the video before this one in this playlist. I break down the motions and the hearing, which I was present for. The court notes that Shanquella Robinson's mother filed this case in Mecklenburg County Superior Court in October of 2024, both individually and as the representative of Shanquella's estate. The claims against Green include wrongful death and battery. The lawsuit also includes claims against Green and the other individual defendants for negligence, civil conspiracy, intentional infliction of emotional distress, and negligent infliction of emotional distress. Then the court walks through how this case moved procedurally. The original state court summons listed the Jamestown, North Carolina address for Emani Green. Then, after learning that Green had changed her name, the plaintiff filed an amended complaint and another summons was issued. Shortly after that, the case was removed to federal court because the FBI and the United States Department of State were also named as defendants at that time. Once the case was in federal court, a federal summons was issued listing the Jamestown address. Later, another federal summons was issued listing a Hartford, Connecticut address. So already the court is showing why this became so technical from the jump. This was not just a simple state court service issue. The case started in state court, moved to federal court, and then eventually came back down to state court. The order also explains the plaintiff's attempts to serve Green. First, they tried the North Carolina address, but the sheriff returned that summons unserved and noted that the defendant did not live at that address, according to the current resident. Then the plaintiff hired a private investigator to try and locate and then serve Green. According to the order, the investigator attempted service multiple times in Hartford, Connecticut, but was unsuccessful. The investigator also determined that Green was traveling frequently between North Carolina and Connecticut. Then, on May 7, 2025, another private process server left the complaint and summons with a relative at the Jamestown address, and this next part was important. The judge noted that after that May 7th service, Green filed documents in federal court asking for more time to respond. In those filings, she admitted being served and listed the Jamestown, North Carolina address. Then she received a second extension, again admitted service, again listed the Jamestown, North Carolina address, and later filed her answer in federal court, raising the issue of insufficient service. So the judge clearly focused on her own filings. In other words, the court looked at the fact that Green was saying service at that address was not proper, while also acknowledging service and using that same address in federal court documents. Then the order addresses the federal timing issue. The court says that after a case is removed to federal court, the federal rules apply to service. Not to get too technical here, but under Federal Rule 4M, the plaintiff generally has 90 days after removal to serve the summons. But here's the important part. If service is not completed in time, the federal court can dismiss the action without prejudice or order that service be made within a specific time. But according to this order, the federal court did neither of those things. The federal court also did not give notice to the plaintiff that it was going to dismiss the complaint for failure to serve. The judge also looked at whether the plaintiff had a good reason for missing the original service deadline. Under Rule 4M, if the plaintiff can show good cause, meaning a valid reason why service took longer, the court can give them more time. And in this order, the judge found that there was good cause. The judge found that service was completed on Green at the Jamestown address based on her initial filings in federal court. The judge also found that the plaintiff was diligent in trying to serve her. The order specifically points to Green's name change and her frequent travel between North Carolina and Connecticut as things that frustrated the plaintiff's efforts to serve her. So the court made 3 key findings. 1. Service was completed on Green on May 7, 2025 at the Jamestown, North Carolina address. 2, the plaintiff made good faith efforts to serve Green before May 7th. And 3, because of those good faith efforts, there was good cause under Federal Rule 4M to retroactively extend the plaintiff's time for service through May 7th of 2025. And that's the ruling. The court found that because there was good cause to extend the time for service, the May 7th service of the complaint and federal summons was enough to give the court personal jurisdiction over Green. So, Emani Green's motion to dismiss was denied. In plain English, Green stays in the lawsuit. Now that Emani Green is staying in, the next motion on the docket is a motion to stay filed by another defendant, Khalil Cook. I'm not going to break down his motions in this video. I will do that later this week. However, the short version is that Khalil is arguing that the North Carolina case should be paused as he feels the more appropriate place for this lawsuit to take place is Mexico, because that's where the witnesses, evidence, and all the legal issues are tied. They are tied to Mexico, where the incident took place, not North Carolina. I'm very interested to see how the court is going to rule on that particular motion. I do believe their hearing is later this summer, but we will break it down more and I'll share my thoughts in the next video. As always, I'll keep an eye on the docket and I'll catch you in the next one.